Then it follows.
I think it follows. Sorry.
All right, so you get hired by a family member to get somebody out of jail. They give you a big, hefty retainer. Let's say you ask for $5,000. You file a motion to get them out of jail. They're out of jail. And now all of a sudden, after the case has been presented to the grand jury says, oh, there wasn't enough evidence for a charge, so they no-bill it. You've got maybe 1 hour worth of work, $5,000 that they've paid you, and your client now comes to you and says, I want the refund. You haven't earned all the money, I want the refund.
What did the contract say? That the money wasn't paid.
The family member paid you $5,000. You've earned 1 hour of it. Let's be generous. Let's say you've earned $500 out of the $5,000. Who do you give the $4,500 to? Your client has come to you and said, I want a refund.
Oh, the client.
Well, the client didn't pay you.
Yeah, because it'd be your client. too.
Can you
They
take
paid it
payment
on their
from a
behalf,
third
it's
party?
theirs, and they have to.
Yeah, you can take payment from a third party.
Yeah, but the
I thought it had to
payment
pass
is
through
for
their
the
hand.
client, so
Contracts with the
technically
client.
belongs to the
Can you
client.
return it to the third party through the
Who
client?
do you owe the money to? Is it the family member or your client?
Whoever you signed the contract, the agreement with.
You can just put
All
it
right,
back
how
on
many
the
of you
card
say you
that
owe it
they-
to the client?
Can you just tell them I'm going to put it back on the card that it came from?
No, it was cash.
Oh, man.
All right, now how many of you say it's the person who gave you the money? So I've got almost half and half. I see some over here that didn't raise their hand on either one.
What
Does
if
the,
it's
how many of you say the attorney just gets to keep it? You take ethics next semester, you're going to learn that you don't get to keep it. What's your question?
My question is, if you charge them like a collection or whatever to begin with in your contract, do you have to give them, I'm not trying to be unethical, I'm just asking.
But don't you call that a
If you charge
retainer?
them a fee to begin with, up till maybe trial, do you have to give them that money?
If the bar thinks that it's an excessive fee, then you will lose your license if you don't give them money back. So what's the answer?
Give them that back?
Okay.
And keep it in a separate account, because on the discipline thing, lots of people don't do that.
Yeah, you got to keep it in your trust account until you earn it. That's also a grounds for losing your license. So let's go back. How many of you say the client gets money?
Wait, what?
The client gets the money? And how many of you say the person who paid it gets the money?
The client could be running a scam. These aren't criminals.
Because you have an agreement with the client, not the person who paid.
Well, your obligation is to client to represent them. Now, unless you have a provision in your contract that says, I'm going to give the money back to whoever pays it, if you don't have that provision in your contract, who do you give the money to? I hear client,
Can you give it to
and I
the
also,
state?
and I also hear give it back to the person who paid it, right? The simple answer, which is not simple at all,
It depends.
it does depend. In that case, what I would actually do is file a lawsuit. It's called an interpleader. You put the money in the court, and you let the judge decide who gets the money back.
Give it to the state.
So that's the easiest way to literally pass the buck when you don't have a provision in your contract. And those of you who haven't had civil procedure yet, that's the example of what a good interpleader does as far as practice. That takes the obligations out of your hand and lets the judge decide who gets it back. You put the money in the court and you add the person who paid it and your client as the defendants, and they go to the court and make claims for who ought to get the money.
So you make them fight it out.
Yeah,
Do they have to pay another lawyer for that?
usually.
Or make them represent themselves.
Can they retain you? Can you let them?
No, I'm out of it.
So now we have 3 lawyers, right?
3 instead of 1. It's a self-perpetuating profession. Did y'all not know that? All right, let's move on to Grigoric versus Sharp. Who has not done one at all? At all? Who's not done? Ms. McEachern?
No, that's me.
Michael, go ahead, Ms. Michael.
Now I know him.
The plaintiff made a
You just did one, right?
Yes.
Okay, I got you, Mark. Go ahead.
The plaintiff made a contract with Edward Lane for the property. Edward Lane contracted with the defendant to draft a site plan for the land. Lane informed the defendant that he was not ready to buy the land, the site plan was approved, and the plaintiff purchased the land. When the plaintiff applied for the building permit, the new county sanitarian denied the permit because the property could not have septic tank. So the plaintiff brought an action against the defendant and his firm to breach the contract. The plaintiff claimed to be a third-party beneficiary to the contract between Lane and the defendant. The trial court instructed the jury that the defendant could be liable to plaintiff if plaintiff established that he was either intended or a foreseeable beneficiary of the contract. The jury returned verdict for the plaintiff and the defendant appealed. The appellate court reversed, saying that plaintiff could not recover just because he was a foreseeable beneficiary. And then the appellate court ended up being reversed and remanded it because the third party foreseeability is not sufficient for the plaintiff to claim third party rights to the contract.
That's it. Does not matter if it's foreseeable, you have to actually be an intended beneficiary. Now, how many of y'all know how septic tanks work?
Or Lane.
Well, except for what you see on commercials on TV.
They're
How
kinda
do they work?
They like
All the
float.
waste goes into them and then they get pumped out.
All the waste goes into them,
They're kind of crappy.
and then they have lines that go out of them, that go into the yard, where it drains into your yard.
Some
Yes,
places are really green.
because everybody wants
If you
to
have a
be
leach, it's really green there.
It's kind of crappy, isn't it?
Pun intended. He's such a loser.
I actually used a pun like that this week in court.
In court, is that what you said?
Yeah. I had a guy who was upstairs in the jail actually spreading it on the walls.
Oh, nasty. Is that a mental?
All right, so septic tanks. Septic tanks actually have lines running to the yard where they can dissipate the runoff of your septic tank. Now, how many of you would want your city's drinking water supply to be right next to? That's what's the basis of this case. The second land inspector said, there's no way I'm approving you to run this stuff right next to our drinking water supply. Even though the first one approved it. All right, the vesting of third-party rights over on 957. Look at restatement 311. Parties to the contract may state in the contract that the beneficiary's rights cannot be altered without the beneficiary's assent. Well, if you're actually saying that, have you pretty much given the third party whatever rights it is in that contract that you've delegated to them? That they have to agree to any changes? Absolutely, that's what they call vested. Restatement in the courts begin with the assumption that the parties who form a contract have the right to change it or cancel it. That's restatement 311 also. However, if the parties to a contract intended to create rights in a non-party and tell the non-party about those rights, the non-party might reasonably consider those rights fixed and definite. The law recognizes this possibility by making contract rights irrevocable when the beneficiary materially changes its position in justifiable reliance on the promise.
Where is that?
2/3 down on 957. Everybody got that? If you tell them that you have given them rights and they do anything in reliance on that, then you cannot change your contract.
But if we don't, you
Well, if you don't tell them that they've got rights, then they won't know. Now, if they sneak around and find out but you never told them, then that might be a defense. So if you want to preserve your right to be able to make changes to it, then you need to not tell them. Yes?
I was thinking about this one already. What about when you have a life insurance policy? And I have told my cousin that they're the beneficiary of the life insurance policy. Wouldn't they be an intended third-party beneficiary?
If they're the listed beneficiary of a contract between you and your insurance company, and you tell them that they're the beneficiary,
Right?
and they do, and how much is your policy? 100,000, 500,000,
3 million?
4 million? Whoever your beneficiary is, you tell them that you've got $1 million coming to you when I die. What do you think they're going to do? Figure out what? Help you die? That's why you don't tell your spouse how much life insurance you have.
I was saying that, because the contract between myself and the life insurance company.
Right.
The third-party beneficiary, intended third-party beneficiary is person A, okay? So,
That you've named.
well, named. So I thought that I wasn't going to be, if they're vested, I don't know how to be vested.
If you tell them about it and they do something in reliance on it.
Right, I can't, let's say they buy a house or something, I don't know, and they know they're retiring in 4 years, and they won't be able to afford the mortgage in 4 years, but they know, I don't know.
That they know that you're going to die within 4 years.
I don't know. So, but can I change my intended beneficiary of my life insurance policy without them giving consent?
If you have told them that they're the beneficiary and they do anything in reliance on it,
I can't.
they may keep you from being able to change your beneficiary.
What would be something they would do in reliance to that now? And it's on a life insurance policy, like, what's an example of something they could do that would cause them to be in reliance of a life insurance policy?
Well, let's say they just bought the house and they're working and making payments, and then you tell them, oh, I've got you named as beneficiary on my $1 million life insurance policy that I just took out because the doctor told me I've only got 24 months to live. And so they've saved up enough money to make 2 years, maybe 3 years worth of house payments, and they say, well, if you're going to die and I've got $1 million coming, then I'm going to retire. Now, do you think that they've done something in reliance on the fact that they're going to be getting $1 million in 2 years when you die?
So when you go to a life insurance company and you change beneficiaries, they don't ask you, did this person rely?
No, they don't.
So if this person ever finds out that I've done it and then I'm not here, they could challenge that at that point.
Yes. And they could say that the second beneficiary designation is void because they relied on your telling them that they were the beneficiary.
Because I was thinking.
And if the court finds out that you told them and they did anything in reliance on it, then the court may well hold that your second beneficiary designation is void, and therefore the first beneficiary gets everything.
Because everything made sense in terms of third-party beneficiary, except for life insurance and wills, because I thought that would be.
Well, a will's not a contract.
Well, sorry, because I didn't recognize that at first. This is what I was thinking. So life insurance, because that would be the only thing that I would think that the contract and the split departments would have to change, but I guess not.
All right, well, let's talk about a situation where a will may be a contract. What if you and your husband decide that you're going to execute mutual wills, and y'all make the agreement that whatever happens, the money's first going to go to whoever the spouse is, and then it's going to go to the kids. And then you have a falling out with your spouse after he's drafted his will up to say that, you've drafted your will up to say that, and then you change your mind after you've told the kids y'all are going to get the money, and you decide, well, the kid's been bad all these years, I'm just going to give it to charity. So you go back in after the agreement with you and your husband to make the wills out to each other and then the kids, and you decide, I'm changing it. Screw the husband, screw the kids, I'm giving it all to charity. So you change the will. Now, you've told the kids that they're getting the money. So the kids, in reliance on that, have not gone to college to learn something like engineering. They've gone for liberal arts, like history, like my youngest. Can't get a job to save his life in history. You have to have at least a master's, maybe a PhD to get something that's going to pay. So they changed their major from engineering to history
A lot easier.
in reliance on the fact that they're going to inherit from you and your husband because y'all told them that they're in the will. Is that a reliance? And is there a contract there when you and your husband have agreed?
Yes.
There's a contract there too, right? Now, might the kids claim that they're third-party beneficiaries of that contract?
Yeah, because
Keep-
they're like 10 third-party businesses.
They may well, right? So you got to be careful in advising them if an agreement comes in and there's consideration and, you know, taking care of your loved ones is probably going to be good enough consideration for a court.
A while back, we spoke about a situation where a person has they've worked for a long time somewhere and they have a pension fund, okay? And so,
Those are almost like dinosaurs these days, but go ahead.
or something like that, right? And so, is a pension fund a contract with your employer?
It's a benefit that arises from your employment contract.
For your employment contract?
Right.
So, let's say that you have like an implied beneficiary, which is your spouse. Is that, because, or does it just go back to what we learned with that ERISA or something? You know, you can't change it without the consent of your spouse?
Yeah, the ERISA, the federal law complicates that. Let's not use employee benefits as an example.
So that's not a good example.
Not a good example. Yes, ma'am.
Wasn't there a defense though on the third-party contract? It was basically, you don't count your chickens before they hatch. So if you're relying on, like, the life insurance policy, the court would look at it as it's not in existence because she hasn't died, so you wouldn't make those decisions.
Yeah, I think there's probably something in there about not counting your chickens before they hatch, but the real question is whether they've done anything in reliance on it.
Okay.
And that's what makes it irrevocable. What's that?
That's from the motive.
Hey, have y'all not heard the expression loose lips sink ships?
Yeah.
Yeah, don't tell somebody that they're a beneficiary. Because if they do anything in reliance on that, then you've basically stripped away your rights to make any changes. Yes, ma'am.
I see that happening in divorces. People get mad and they change that.
And if I was writing a policy for a husband and wife, I would make the wife the owner of the policy. That way the husband couldn't change her as the beneficiary without her permission. Because only the owner could make the change. Wow.
Unless they assign that right to somebody else, which is, you know, assignment, I think, is this week. So yeah, it does depend on who's the actual owner of the policy. That's also a good thing to do in divorces, by the way. If a person doesn't own the policy, then the court can't give it away to somebody. It's not marital property if they don't own it. All right, look also at the restatement on top of 958. The second restatement eliminates the distinction between donee and creditor beneficiaries. We talked about that last week. First paragraph on the top of 958. Second restatement of contracts eliminates the distinction between donee and creditor beneficiary and recognizes that modification on the part of the promisor and the promisee is ineffective only if the agreement provides unless the third-party beneficiary has changed his position in reliance on the promise or has accepted, adopted, or acted upon it. That's the test. If you've told them and they accept, adopt, or act on it, then you can't make the change. All right, claims and defenses that are applied to third-party beneficiaries. That first paragraph, corollary, the beneficiary's rights are subject to the same limits as were the rights of the promisee in the original contract. So, the beneficiary would be subject to attacks such as lack of consideration, failure to satisfy the statute of frauds, mistake, and incapacity. So they can assert the same defenses as the party to the contract. He also is subject to any claims the promisor might have for breach of promise by the promisee up to a point at which the promisor's claim against the promisee would extinguish the beneficiary's claim against the promisor. Technically, that's called a set-off. S-E-T-O-F-F. Their liabilities up to but not exceeding that amount. So that's set-off. Next paragraph down, the courts generally hold that the beneficiary must take the bitter with the sweet. If she wants to pursue a claim created under the contract, she can only do so in the venue chosen by the contracting parties. So if the contracting parties agree that they're going to arbitrate any disputes, the third-party beneficiary has to arbitrate any disputes. All right, delegation of duties. Sorry, what? All right, notice that there are duties and powers got split up in our reading assignment. So they consider them differently. This is the delegation of duties, and then we go into delegation of powers. All right, delegation of duties. To say that a duty is delegable signifies that the holder of the reciprocal right cannot object to having the duty performed by someone other than the initial obligor. Does everybody see that? What kind of duties do you think would be delegable?
Like mowing your lawn.
Yeah, mowing your lawn. You contract somebody to mow your lawn, do you care who mows it?
No.
Or you just care that it gets mowed? All right, now what I thought about when I read this is, you go in and you have an appointment with a senior partner at a law firm to handle a legal matter for you. And you agree and you hire that senior partner to handle that matter, and the first thing that happens is they pass that file off to an associate who just passed the bar. Now you've gone and seen this lawyer who's been practicing for 30 years. They've told you everything's going to be all right. You know that it is. And then when you walk into court, you see this associate lawyer, and you come up and say, well, is it going to be delegable or not? And the associate lawyer looks at you and says, is what delegable? Does that give you confidence? How many of y'all have actually had that experience? Yeah, it's scary, isn't it?
So I've had that experience at a doctor's office, and I actually stayed with a doctor that my insurance no longer covered because I switched insurances, but I stayed with them and I paid cash out of pocket. And they weren't there during one of my appointments. They put me with a nurse practitioner. And I complained. I said, when I'm paying out of pocket for a service, I'm paying for the person with the medical degree, not the practitioner. So, and I asked them not to do that again, and they haven't. Because I'm paying for your expertise, not the
And another thing about the insurance is, insurance will pay for a doctor visit. They don't pay for licensed nurse practitioners. Not unless your insurance contract's been updated.
My nurse practitioner comes in and then the doctor comes in behind her to verify.
Yeah, well, I've been to one of those dock in the boxes where it was a nurse practitioner, and my insurance company didn't pay for it because it wasn't a doctor. Learn that lesson. Don't go back there.
Mine does, and the copay is actually cheaper if you see bills.
Tom?
They bill at a different level.
They do bill at a different level. So the question about whether or not it's delegable, are you going to object to somebody else doing the work? Then it's probably not delegable. Personal services are one of those, like when you hire a particular artist to go in and star in a show, you don't want to see the understudy, do you? Do you ever feel ripped off when you go to see like Shirley MacLaine do this whatever show she's doing, and you come in, you find that it's somebody who's only done off-Broadway work? Yeah. They do okay in the show, but didn't you really pay to see Shirley MacLaine? All right, look at the middle of 960. The performance is a type the court suggested that depends upon the identity of the party that is to perform. And then they mentioned restatement section 318 at the bottom of that paragraph. So if it depends on the identity of the person who's to do the work, it's probably not delegable. Now, when you delegate, does that completely relieve you from responsibility?
No, because you're overseeing.
That's the top of 961. Delegation is not absolution. For absolution, the assent of the obligee is required. And then when the obligee actually assents, it's called a novation. So that's what gets you off the hook, is when they agree, you delegate the powers and the person receiving the service agrees to it. It's not a delegation anymore, it's called a novation. They've actually agreed to substitute performance.
So it's the difference between like a sublease and just finding a new tenant
Yes.
for them. Okay.
You're actually substituting a person that's responsible. Now, that's one of those crazy languages in a lease that says that the landlord has to approve any subleases. Well, when you lease the entire space to them, and the landlord agrees to allow somebody else to make the payments for you as a sublease, it's not really a sublease anymore, is it?
No.
You're not keeping part of it. You're giving the whole thing away to somebody else. That's where you argue that it's a novation rather than a sublease. And some landlords aren't sharp enough to catch that. All right, top of 962. Covenants are either personal, enforceable only by the original parties to an agreement, or they run with the land. So when covenants run with the land, they are enforced against the remote grantee. First of all, do y'all know what covenants are?
Yes, things you have to abide by.
Just the letter.
HOAs.
Yeah, HOAs are an example of covenants that you're going to be a member of it, and you're going to pay whatever they tell you to pay, and you're not going to do whatever they tell you not to do. And so if you have a piece of property that you're looking at, and you go and look it up and see that there are actual covenants that are recorded against the property, then those covenants are going to run with the property, and you're going to be subject to those covenants, even if you're the fifth or sixth owner down the line after they were recorded. Everybody see that? But if you actually say to an individual that you promise, this person specifically promises not to build a chicken farm next door to you, is that a personal promise? It might be personal, because does it restrict anybody else from building a chicken farm?
No.
Only restricts that person from building a chicken farm, right? So you got to look and see what's the intent of the parties. That's going to be one of those third-party beneficiaries too, that once they set up the covenants, which is the agreement, and you buy into that neighborhood 20 years later, are you really the third-party beneficiary of that original covenant? You might be if that's what you're expecting in your neighborhood. Yes.
Would historical landmarks be a part of that? Like, you know, sometimes you could buy a house that's just a historical landmark, but you can't like change anything or do any renovations, or would that be something completely different?
That gets complicated because sometimes that's federal law if it's on the Federal Register, or it may be state law if it's on the State Register of Historical Places. So it's not necessarily an agreement, it may be a law. But you got to look out for covenants and laws, like zoning ordinances. You may not be able to operate a home business if you're not zoned to do business. If it's strictly residential, you may have to get a variance. All right, another non-delegable duty is that of an attorney appointed as a guardian for an incompetent person. This is the last paragraph above UCC Article 2 on 962. A sanction can be imposed on the attorney for having a delegated responsibility for managing that person's assets to an assistant having failed to supervise the assistant. Now, do you want to delegate control over your trust account to anybody? No. Okay, this isn't even ethics yet. Y'all take that next semester and you know, don't give anybody control over the money that you're in control of that doesn't belong to you. And that's what a trust account is. When somebody pays you money and you put it in the trust account, you're personally responsible for what happens to that money. Do you ever want to give somebody else responsibility for writing checks on that? Yeah, you'll lose your license. That's one of the things that the bar takes your license away from the quickest, is mismanaging other people's money and other people's property. Now, here's where I actually wrote the note in here about attorney contracts, associate versus partners, where if you hire the senior partner, do you really want the associate showing up for you? Huh?
It happens.
Oh, all the time. And here's what's even worse about it. They both show up. The senior partner charges $500 an hour, and then they charge you $300 for the associate to be there too. Now you're paying $800 an hour for an attorney, 2 attorneys to sit in court.
I would agree to that.
Do you have a right to say, what is the second person here for? I can't afford both of you and send one of you home? I mean, do you have that right as a client?
Signing the attorney's contract.
Yeah, it depends on what you signed in your attorney's contract.
Associates got to learn at some point.
What?
Some people will even need an attorney to be able to
They do. In fact, if your attorney contract has in there something about arbitration, I'll give you this practice pointer real fast, since it is contracts after all. If you put in your attorney contract that you and your client agree to arbitrate any disputes that arise between the two of you, our Alabama State Bar has said you need to tell them that they need to hire an attorney to go over your attorney contract.
If there's an arbitration.
If there's an arbitration clause in there. Because they're supposed to have independent counsel as to whether or not they want to agree to arbitrate any disputes with their own attorney.
They can waive that, right?
Yeah, they can waive that. Yeah, but I'd have something written in my contract that says, client has been advised that he needs an attorney to review this document before he signs it with another attorney.
But then if he goes to the other attorney will have a contract, so then what is he supposed to do with that?
Depends on if they have to require me to arbitrate.
Can you look at his requirement and he look at yours?
Yeah, you can do that. You want to know what the simplest thing is?
Don't put it in there.
Don't try to make your clients arbitrate.
I was gonna say, is that a common conclusion?
We're arbitrating with our builders. We sign an arbitration.
Yeah, arbitration is one of those things it's best stayed away from
Yeah.
for lawyers, because you don't want to induce your client to go to another lawyer because the other lawyer just might do a better job representing them on the thing that you sent them to look at your contract on. And they'll cut you out completely. All right, bottom of 962, UCC Article 2 and the restatement 2-210 and restatement 318. It says, if the other party has a substantial interest in having the original promisor perform or control the acts required by the contract, then it's probably not going to be able to be delegated. And the test is a substantial interest. All that last section, it all boils down to a substantial interest. Do they have a substantial interest in the senior partner versus the associate? Yes. Do they have a substantial interest on who cuts the lawn? No. I'll tell you a funny story about my neighbors. My next door neighbors, I think they're both Chinese citizens. I will see her out in the yard digging up weeds with a fork and cutting the grass with scissors.
No.
I had a neighbor like that,
Yeah. My neighbors do that. It's like, it looks relaxing, and I'm not gonna do it. Like, he looks relaxing.
I think it'd be more relaxing to drink beer.
And they're,
Beer and watch my neighbor cut his
and they're probably not very happy with me because some of the weeds, I'm sure, blow over from the weeds that the seeds blow from my yard to theirs.
My dad's
But
Especially
hey,
when you're out there.
she looks like she's having fun digging up weeds with a fork.
I had to use Google Translate to talk to my neighbors once because their cameras were pointing into my house and they didn't speak English like at all. So we had to use like Google Apps and it's terrible.
I hope they worked right.
They moved the cameras. It was good enough. But
All right, look at 963. The delegation of a contract obligation does not itself absolve the obligor of its duties. Again, that's 2-210. What does absolve you of the duties?
that other contract.
The novation.
The acceptance, in other words, a novation. If the other party accepts the delegation, then it's a novation, and that actually does absolve you of the duties. All right, terms of delegation, 963. Second paragraph, UCC did not govern the case, but it speaks to analogous cases in which seller or buyer of goods makes an assignment in terms that are similarly indeterminate. They say, of the contract were all of my rights under the contract, or an assignment in similar general terms. The assignment is also a delegation of performance of the duties of the assignor. So what you want to do is avoid general terms. You want to be pretty specific if you're going to delegate it. Now, if you say, I hereby delegate all my duties to somebody else and the other side of your contract, the other party to the contract says, okay, then that general assignment of all your duties actually is a novation. All right, introduction to Sally Beauty Company versus Nexus Products. That intro paragraph didn't do a thing for me. Let's go to the case itself. Who has not done one at all this semester? Has everybody done one? Ms. Dudley, you have one. Who's not done one at all? All right. Who has been called on and was not prepared? All right. What's your name?
McNeil.
Okay, Ms. McNeil, this one's yours.
All right. Sally Beauty Company versus Nexus Products Company, 1986, in United States Appeal, 7th Circuit. Okay, Sally Beauty Company acquired Best Barber Beauty and Supply Company, which has an exclusive best effort agreement to distribute and promote Nexus products, hair care products in the Texas market. In a merger and acquisition, because Sally Beauty was a owned subsidiary, Alberto Culver, one of Nexus competitors in the marketplace, Nexus refused to continue its agreement with Best. Sally Beauty sued Nexus for breach of contract in violation of antitrust laws.
Nexus moved for summary judgment on the breach of contract claim. The trial court granted the motion, finding that the contract was not simply an ordinary commercial contract, but one based upon a relationship of personal trust and confidence between the parties, and Sally Beauty appealed. And the issue was made the duty of performance under an exclusive distributionship be delegated to a competitor in the marketplace, or to wholly owned subsidiary or a competitor without the obligee consent. And the holding was no. The duty of performance under exclusive distributorship may not be delegated to a competitor in the marketplace or to the wholly owned subsidiary of a competitor without the obligee consent.
Okay, did you read the dissent?
Yeah. Sally Beauty distributes hair care product supplies made by the many different companies, which appear to compete with Alberto Colbert as vigorously as Nexus does. As most so far as the record shows, Nexus may have grounds for insecurity regarding the performance of Sally Beauty of its obligation to use its best effort to promote Nexus products. And if its remedy was not to cancel the contract, but to demand insurance or due performance. No such demand was made.
Okay, so which is the better decision? The majority decision or the dissent?
I'll say majority.
You think the majority's better? They call it a personal contract?
Yeah, I do.
All right, let's go back and examine what actually happened. Alberto owns Sally Beauty, right?
Yeah.
Y'all know the company Alberto? Alberto VO5?
Oh, I thought that was like painting.
No, it's a real product. So that company has acquired, apparently it merged with somebody called Culver. And now they've gone out and bought Sally. So it's a wholly owned subsidiary. So they're building up almost what appears to be a monopoly in the beauty supply market, right? Except Nexus comes along, and they have a pretty good market share themselves. So when Alberto bought out Sally Beauty, there wasn't a problem yet, was there? But when Sally bought out Best, they're saying that there was a delegation in there, wasn't it? All right, let's talk about what is an actual delegation. You're delegating it to somebody else, right? Is Best not now part of Sally's if it was bought out by Sally's? Are they really delegating anything to Sally's? No. They're owned by Sally's, right?
Yeah.
So Sally's technically is the owner now of that contract. They're not a delegated third party. They are the owner because they bought them out. So is the original or the majority opinion good in that it says it's a personal contract that's not delegable when in fact it's not delegated at all? It's bought out. So is the majority opinion any good?
Well, it wasn't what they bargained for. They didn't bargain to have their business turned over to a competitor.
Then they shouldn't have had it with somebody that could be bought out by somebody else.
It's true, but in this one I would have saved my money anyway because it was only for a year. I mean, the litigation alone would have tied up. I mean, how much damage could they have done in a year? It was a waste of money, if you ask me.
Didn't they
Well-
still have incentive to push the product to make profit anyway?
They do have the incentive to push the product and make a profit because now they've got not only the Alberto products, but now they've got the Nexus products. And if they don't push to sell all of it, who ends up losing money if they don't make the sales? Sally's does, right? So does Sally's have an incentive to actually sell both products to do the best that they can?
Yeah, because if they do anything less, they're not gonna be sued for that.
That's what they were saying, though,
They could
that
be sued for
within
breach
a
if they
year
didn't do
that
it.
it was,
So under the UCC that you've studied so far, was there a reasonable basis for Nexus to think that they may not use their best efforts to sell the product?
yes.
Maybe, right? And so what's the remedy if you've got a reasonable basis? Demand assurance. So who actually got this opinion right? I think the dissent did too, because they actually applied the UCC to make the decision, where the majority just came in and made up stuff about it being delegated. Was it really delegated? It was assumed, right? Because the buyer assumed the duty. Best is still a wholly owned subsidiary of Sally, right? Just like Sally is a wholly owned subsidiary of Alberto. So when you start reading these things and get the familiarization with the UCC, you can see how some of these judges go off on tangents. What that tells me is that they cited this case the way they wanted to and then wrote an opinion to justify it. Isn't that what it looks like? They called it a personal contract. Well, how many of you say that corporations are personal?
Sometimes you need to pierce the corporate veil.
I got an assignment on that.
All right, so the majority does say that Nexus may have had grounds for insecurity regarding the performance by Sally, but they did not demand the assurance. Now to 969, assignment of rights. Well, that section was assignment of duties, right? Delegation of duties starting on 959, section 2. Now on 969, section 3 is the assignment of rights. So they look at it from both sides. What are the duties you have to do under a contract? And then what are the rights that you receive under the contract? They mention specifically restatement 334 and 317. Down at the bottom it says, the substitution of right as an assignee for the right of the assignor would materially change the duty of the obligor. Can't do that. Not if it would materially change. Then they also talk about the attempt to delegate constituted a repudiation. So again, you have to think about what you're doing before you do it, because your attempt to give somebody else the rights under the contract may actually repudiate the contract. Mentions 2-202. And then it says, it's not so, however, when the assignment would materially change the duty of the other party. And this is ice for ice cream, the example that they gave. Is it different supplying ice to a mom and pop shop than it would be to Barber Dairy? A huge corporation? If you promise to supply all the ice needed for the making of ice cream to a mom and pop shop, that's one thing, right? Yep. But if mom and pop is bought out by Barber, and now they have the right to all the ice they need to produce ice cream at Barber, does that materially change? Yeah, because it's a whole lot more supply that they're going to demand, right? But that's their rights, is to get all of their ice from this provider. But if they get bought out, it could materially change it. Article 9 governs most assignments of payment rights. And then Article 9 is largely beyond the scope of this course. Now they say that, but in the rest of our reading assignment, it's all Article 9. So you're going to have to know what's in this book for your exam. And they're going to test that on the bar too. All right, note number 1. The other party may treat the assignment as creating reasonable grounds for insecurity. And then they point to 2-609 about the ice cream. Now, Herzog, anybody else been called on? Okay, Ms. Kafka, go ahead.
Herzog comes from the Supreme Court of Maine. It deals with an instance between a law firm and personal injury firm where the client was involved in a motorcycle accident, and unrelated to the motorcycle accident, he sustained some shoulder injuries at some point. He asked the attorneys to assign proceeds from his settlement to pay for the surgery on his shoulder.
Now, before you go any further, that's called spending money you don't have. All right, go ahead.
Yeah, he counted his chickens before they hatched. So then, when at the end of the settlement, he then directed the attorneys to not pay the doctor, even though I believe they had already cut a check to the doctor, and for treatment for Dr. Herzog for 1 year. The settlement was 20 grand, and the doctor went to cash the check and it was returned, but he was never paid. So the court looked at this for assignment of benefits from the proceeds of the sale, or I'm sorry, the proceeds of the settlement. And the court ruled that it was a valid assignment and that they were not doing, the attorneys argued that it would be unethical for them.
That's what they argue.
Yeah, that's what they argue, that it's unethical. The court said it's not, that they can use the assignment.
So what happened in that case?
The court said that the district court, the assignment was valid and it was enforceable against the lawyers, Iris and Lowry.
So the lawyers had to pay the medical bill for the shoulder surgery, right?
Correct. Yep.
After they had given the client all the money,
Yes.
the lawyers had to pay for it. Now, don't you think lawyers should have known if that was a valid assignment or not?
Yes.
So who's really at fault in this case?
The lawyers. Well, and it was odd that they would assign a surgery that was unrelated to the personal injuries suit. Because it was an injury that wasn't from the motorcycle accident.
Right.
That's what seemed, when I was reading it, it seems odd to me that.
Well, they needed the money. Here's the problem. Lawyers are ethically prohibited from lending money to a client. So could the lawyers have lent them money for the surgeries?
No.
No. The biggest asset that client had was what he was expecting to recover from his accident. So the attorneys, being sympathetic to the need of their client for the surgery, who were ethically prohibited from lending the client money, said, aha, we'll do the next best thing. We'll let you use your money. And that's the assignment that they signed and sent over to the doctor that says, we'll secure the payment of your bills with the money that we recover. And oh, by the way, since the surgery is only going to be this much and we expect to cover more than that, your entire bill ought to be paid. Does everybody see that? Mm-hmm. Now, there is an ethics opinion for Alabama that says that if it's bills related to the injury and the attorney says that I will pay this from the recovery, what you can do, if you write one of those security letters to the service provider for the injury, then you better pay it off. And it's similar to, it's their money now, and if you don't pay it off and you give it to somebody else, you've mishandled somebody else's money. You know what that happens? Yeah, you lose your license to practice law. And it is grounds for attorney discipline otherwise, and it's probably going to be losing your license. Y'all know what the sanctions are, right? Private reprimand, public reprimand, suspension, disbarment.
So if you lose your license, do you ever get it back? Like you
Sometimes.
make one mistake and then they're like, oh well.
I know a lawyer that's still trying to get his license back after more than 15 years.
So can you go and get his license back once he gets out of prison?
I doubt it.
But then your name is published in Alabama Lawyer, where all judges and attorneys read it, and it's in the
Oh,
back under disciplinary.
It's better than that, because now they're changing the website to put your attorney discipline history out on the website for everybody to see.
At what point does it become publishable? At the sanction level, at the public reprimand?
It's going to say that you were subject to discipline on the webpage, but if it's public, or a suspension or a disbarment, then all that's supposed to be out on their webpage. And that's coming, I think, this summer.
Realtors do that too. We do that too. We put everything in.
Well, it's that kind of information that's available. I'll tell you all this. I had surgery last year, and before the surgery, I didn't think about it, but my wife did. She's a lawyer. She went and looked up my doctor on Alicourt to see how many times he'd been sued for malpractice. Now, for lawyers, if you want to hire a lawyer, you might want to find out how many times that they've had malpractice, right? Or how many times they've been sued. Look them up on Alicourt. Or how many times that they've actually had attorney discipline. Now that's going to be available on the State Bar's website.
Have you ever been disciplined?
No.
Okay, so, I mean, it can be avoided completely, right?
I don't know how I've done this, but practicing criminal law and domestic relations law for over 20 years, never had one.
And if like just a mad client complains on you and they investigate, I mean, they're obviously going to see if you didn't do anything wrong.
That's the other thing. If the State Bar sends you a letter that says respond to this complaint, you better respond.
Right.
You can get suspended for not responding to the letter. And yes, I've actually helped attorneys out of disciplinary investigations.
So you're the guy.
And usually the more information you provide to them about how crazy the client is, the better. They close out the file. There's several levels of it. You'll get a lot of this next semester in your discipline or your ethics. But when they get a complaint from a client, the State Bar comes in and sends you a copy of it, tells you to respond to it. And then when they get your response back to it and the complaint, they look at them together and they decide whether or not it even merits opening up a complaint. They summarily close out, I think they said 75–80% of all the complaints that come in without having to do an investigation because they know they're just crazy complaints. Some complaints like GALs over in family court, this GAL was against me. Well, they're the parent. They did something stupid. They smoked drugs in front of their children. Yes, I don't want you to have custody of your kids anymore. They'll send in a complaint to the bar that this attorney did this to me. Well, your response back to the bar is, it was my job. And then those are summarily closed out. They're really looking for whether or not you breached a client duty to an actual client of yours or mishandled money belonging to somebody else.
Is there a list somewhere of crazy clients that attorneys can see?
How many times have they complained?
You can make your own list. And then when they call you up and say, I want you to represent me, I'll give you an example. I got this guy out of prison almost 20 years ago. Sent him the bill to get him out. Did a Rule 32 or a habeas or something. Got him out of prison. He was there illegally and I got him out. I sent him a bill. I think it was for $500. He still owes me $400. He called me up this week and he said, hi, this is me. I said, who's that? The one that still owes me $400? I want you to do some work for me after you paid the $400. Well, I can't do that now. You wouldn't be out of prison if I didn't get you out. Pay my $400. He called me up years ago and says, I want to get you on retainer. Not until you pay my $400. So is there a list of crazies? Yes. But it's usually yours. Keep track of everybody that doesn't pay you. All right, let's get back. 972.
You wanted to get him on retainer.
He's a horrible person.
Yeah. He's in the shenanigans.
At no interest?
Where's all the interest at, you know?
Yeah, what's it like total up to?
I'm never going to work for him again. I have more fun asking for the $400 than I do. Even if he gave me the $400, I wouldn't take it so I could complain about it. Yes, sir. Okay. 972, validity of assignment. I have the rest of that entire page highlighted because it's good stuff. That's all good stuff to know. A lot of that's what they call black letter law. It's what the law is. So know that. Top of 973, an equitable assignment need not transfer the entire future right, but rather maybe partial assignment of that right. Ethical obligations. A little further down, the rules say nothing, however, about a client's power to assign his right to proceeds from a pending lawsuit to third parties. That's the case we just covered. About the middle of 973. Middle of the paragraph, second paragraph under ethical. Because the client has the power to assign his rights to funds held by his attorney, it follows that a valid assignment must be honored by the attorney in dispersing funds on the client's behalf. Well, now, if the attorney's holding funds for a client, and the client can assign those funds to anybody, and you have the duty to disperse it according to however the client tells you to disperse it, can you think of another instance where somebody else is holding money on behalf of another person? Escrow is an example.
You know, you see those commercials like,
It's my money and I want it now.
Yes, is that
Those are structured settlements.
yeah, structured settlement. Is that kind of the same, similar? In reverse though?
What was this?
I'm just trying to get a real simple one. Who has most of the money that you have right now?
The bank.
The bank. The bank's holding your money. And if you tell the bank to give some of it to somebody else, they have the duty to do that. How do you instruct the bank to give money to somebody else? You write a check. Pay to the order of, and they're supposed to pay that money over to that person, assuming you have enough in your account.
Professor Bodie?
Yes, ma'am.
The companies that you see where they say, you know, we'll give you money now while you wait for your settlement. How does the attorney,
That's what we're talking about here. They can assign the right to recover to their money that is recovered.
okay, but it would be paid to that, high interest loan?
I don't know what their terms are.
Okay, but the attorney would have to pay that because it was assigned?
Yes.
Okay.
If the client actually recovers.
Okay.
If the client doesn't recover and you don't have any to pay out, then there's nothing to pay.
What if they die? While you're representing them, you just turn it over to the state or the court, or you get to keep it because you did up until their life was over?
Beyond the scope of this class. You have to actually substitute parties, and that's more complicated. All right, means of assignment. Restatement 332 on the bottom of 973, 324 at the top of 974. And it gives us examples of the language for assignment. Look at paragraph A. JVS hereby assigns and sells to Rexford as absolute owner, and Rexford hereby purchases from JVS certain accounts which arise from JVS's sales of merchandise or rendition of services. Y'all see that? That's a good example of an assignment. What are you actually assigning in this paragraph? Yeah, y'all know accounts receivable. How many of y'all did any accounting in undergrad? You are assigning your accounts receivable. Now, what goes along with assigning accounts receivable?
Collections.
Collections, and what else? Bad accounts. The ones who just aren't going to pay. So, if you have an assignment here, like in paragraph A, where you're assigning all of your accounts receivable over to somebody else, how much is that person going to pay you for your accounts receivable? They're going to give you penny for penny the amounts that... They're probably going to give you a percentage, right? Now, they understand that when they assign those accounts over, well, you assign them over to them, that there's probably going to be some accounts that aren't going to be paid. So there's a risk that they are taking that some of that money is not going to be paid. So how do you make money when you do that?
Insurance.
Get insurance?
The bad accounts.
You do what?
You collect on the bad accounts.
Yeah, if you can get them. You want to collect on the bad accounts? You want to collect every penny you can from those, right? Now,
You give them a discount.
you discount it, not only for the time value of money, but also for bad accounts. You all know what the time value of money is, right? How many have never heard that term? All right, how much is $1 worth today? How much is it worth tomorrow? How much is it worth 6 months from now? It might be worth more if you had it invested somewhere, right?
Yes.
So it's not only the dollar, but it's what the dollar can earn in that amount of time. So that's the time value of money. Not just what it is worth today, but what's it worth in the future. Now, discount that by the amount of bad accounts. If you buy $10,000 worth of accounts receivable and your experience tells you there's about 10% of that that's not going to be collected, how much do you want to pay for that $10,000 worth of accounts receivable?
Under 9,000.
I wouldn't pay any more than $9,000 for the $10,000 because that's what I expect to get back out of it. But that $10,000 today, which I pay $9,000 for now, how much would that $9,000 have been worth had I kept it for myself after I take into consideration how long it takes to receive that money from the accounts receivable? You see how it gets complicated? There are people out there that do these calculations all the time as to how much to expect to get back in when you buy these accounts. That's why they discount. They give you less than 100 pennies on the dollar. Sometimes it'd be 90 if that's their experience. Sometimes it's 80. Sometimes it's 75. There are companies out there called factoring companies. That's what they do, is they buy accounts receivable. There are some out there that buy accounts receivable from attorneys. Whenever you have money that you are due to be paid and you need the money now to keep your lights on, you can sell your accounts receivable to these companies who will give you money up front, knowing that you're going to get this money on the backside. Everybody see how that works? So they don't give you 100 pennies on the dollar what it's worth. I think most of them do like 80 or 85%. What's that? Was it 80? I think they're around 80 or 85%. And then you get that money up front, and then they get the money from whoever's paying that bill.
They go after the client.
They can go after the client, but you know the accounts that they want to buy first? The ones that the money's due from the state of Alabama. And why do you think they want to do that? Because more likely than not, the state's going to pay their bills, right? So if you've got accounts receivable for money that's due from the state, that's a good way to get your cash flow going on your business. Sell it to a factoring company. All right, let's go down to example B. Rexford transferred funds to JVS by way of a document much like this. Rexford funding, pay to the order of JVS Power Sports, and then however many dollars. Y'all know what that looks like?
Check.
Looks like a check, right? Now, does a check have to actually be on paper? Oh, y'all haven't run across this case yet, but you will when you get to, if you ever take tax law. I don't think you have to take it anymore. There was a taxpayer who owed money to the IRS that wrote these magic words, paid to the order of, on a pig and sent it to the IRS. And because it contained all the magic words for the bank to honor it, it was considered a check. And when the IRS didn't cash it, it was too bad for the IRS. Now, y'all heard the stories about people going in and paying court costs with pennies, right? This guy was smart. He wrote everything on the side of a pig.
So what ended up happening with it?
He didn't owe the money because he had tendered the money to the IRS and they didn't cash it.
What happened to the pig?
I don't know. They don't always give us the Paul Harvey side of it. You know the rest of the story? All right. Notice the first thing in the paragraph below that. A check is not an assignment. A person with an account at a bank enjoys a claim against the bank for funds in an amount equal to the account balance. Under the UCC, a check is simply an order to the drawee bank to pay the sum stated, signed by the maker, and payable on demand. That's your three requirements. Signed, a certain sum, and payable on demand.
So is there three things of an assignment? Or of a check?
No, that's three things for a check, which is not an assignment. It's simply an order telling you to pay off whoever this is. Now, the recipient may present the check, but if the drawee bank refuses to honor it, the recipient has no recourse against the bank. Your recourse is against who? The one that wrote the check. That's why it's not an assignment, because it doesn't transfer the responsibility. All right, now, example C. A writes to B, please pay to C the balance you owe me. Is that an assignment? Well, how much is the amount you owe me? All right, look at D.
So is it yes or no?
It's probably not an assignment because it doesn't look like it's specific enough. All right, D. Any money advanced by Mr. Drew for the purposes of manufacturing the radome will be paid immediately to him upon the receipt of counter's remittance, irrespective of any other demands from other creditors. And the case said language in the present transfer is wholly lacking. So that's not a good assignment either. Now, do you notice the difference between A and D? Assigns and sells to Rexford as absolute owner, and they hereby purchase certain accounts which arise from JVC sale of merchandise or rendition of services. That's pretty specific, isn't it? And that's been held to be a good one, where on D it's completely lacking. Courts have uniformly recognized that an agreement to pay out of a particular fund without more is not an assignment. It's simply a direction. So does everybody get what an assignment is in this case? If you don't have any recourse against the party, it's not a good assignment. Is that a good general rule for you? If you don't have any recourse against them, it's not an assignment. So do you have recourse against the bank for a check? No, not if they don't honor it. Your recourse is against the person that wrote the check. However, if your recourse is against the actual person that received the assignment, then it is an assignment. All right, ebb and flow. An agreement to pay out of a particular fund, however, in its clear terms is not an assignment. U.S. Supreme Court actually ruled that a fee earned by Barnes as an attorney became subject to an equitable lien in soliciting the assistance of another attorney. He had earlier said, I will give you 1/3 of the contingent fee which I have coming to me. Is that an assignment?
Yes.
Well, the first thing it's called is well, it's not a referral fee, because he went in and consulted the attorney after the fact, right? So it's simply a splitting of fees. Not, yeah, it is an assignment. The Supreme Court held that it was. And when you read the rest of these, they seem to want to try to carve out an exception for attorneys. But the Supreme Court came back later and said, no, it's not just attorneys. Whenever there's an equitable assignment, it's an equitable assignment. So he had delegated some duties to that other attorney on the contract, so his right to receive some of the proceeds became the assignment because the recourse was now against that attorney and not against the client they consulted with. Sarah Boff versus Mid-Atlantic Medical, down at the bottom. Rebuffed an argument for applying the typical rules regarding equitable liens and denied that Barnes announced a special rule for attorneys. So equitable liens, you are entitled to the money. Notice also the last sentence in that paragraph. Now that the court defers largely to state courts in elaborating general law, it may be that the ruling is authoritative only when it influences a federal interest. That has to do with the division of state and federal courts. I'll give you kind of a hint on it. The U.S. Supreme Court is the final word on federal issues. State Supreme Courts are the final word on state issues. So what they're saying here is whether or not you have a state right to something needs to depend on what the state court says, not on what the federal court says, unless it implicates a federal interest. And then if it implicates a federal interest, the federal court makes that decision. All right, gift assignments. Striking distinction between for-value assignments and gift assignments. An oral assignment by way of gift is effective given appropriate wording. What you ought to get out of that is that there does not have to be any consideration for an assignment. No consideration. Assignments can be done without consideration. What's a good example of a gift assignment to somebody?
Some land?
Some land? Car. When you want to give a car away, instead of doing a bill of sale, you do a bill of gift. And you write it up, it says, I hereby give this person this car. The reason...
To keep them from paying taxes?
Doesn't it have to be $1?
No, it does not have to be $1. A bill of gift is strictly a gift.
What are the benefits of that with a car transfer?
I don't have to keep paying insurance on it. Once the car belongs to them, I don't have to buy the tag for it anymore, and I don't have to pay insurance.
I guess what would be the benefit of that versus doing $1? Like,
Your child now has transportation
Why not sell it to them for $1?
because they have to pay taxes on the expense.
Okay, so they don't have to pay taxes on the car anymore if there's a...
Not if it's a gift.
So when you
That's
go
a
to-
federal gift tax.
So when you go to swap the title, you don't have to pay the 2% or whatever.
Nope, you don't have to pay 2% of the sales price because there's no sale. It's a gift. So there's benefits to giving cars to kids, particularly if you want to get a new car or a newer car and the child needs transportation. Give them your old car because you're not going to get the trade-in for what it's worth. It may be worth more for your child to have transportation than the measly amount you get for a trade-in.
So a game show would be still a bill of sale, right? Because there was consideration of you.
No, then you have to pay taxes on it because
Right.
it's a gift tax. All right. Section 332 of the restatement says, except as stated in section, a gratuitous assignment is revocable and is terminated by any one of a number of incidents, including the making of a conflict assignment at the assignor's death. All right, so let's say you give little Johnny a car, but you just tell him you're giving it to him. But then in your will, you give it to Sally. So does little Johnny, who you told an oral assignment, does little Johnny still have the right to the car? Or since you've made a conflicting assignment to Sally, does Sally have it? Well, Sally's got a writing. Sally's got a writing. It's called will.
It has to be authenticated and contested, really.
Oh, once the will gets submitted to probate, it's already authenticated. So who do you think wins, the oral or the written?
The written.
I think little Sally has a better claim, don't you? All right, ways on which a gift assignment may be made or become more durable than that: delivery of a written and signed assignment. And then another one is symbolic, a delivery of a symbolic or an evidentiary writing. What do you think a symbolic writing is for a car? The title. You sign the back of the title and give it to them. You don't have to physically lift up the car and take the car to them. You give them the title, and that's symbolic of the entire car. Yes, ma'am.
The example you just gave of the wheel of the car, what if he made reliance on that?
Ah, that changes it, doesn't it?
Yeah, so if he relied on that, changed it?
If he relied on it by selling his other car because now he's got a better one, I'd say that that's irrevocable then. Another is sometimes operative is the expectable action or inaction on the part of the assignee induced by the assignment. Don't go buy another car, I'm giving you one. So if they don't go buy a car, then that might be enough for it to be a valid assignment. All right, sale versus a loan. Here's your factoring agreements. Factoring is the buying of accounts receivable at a discount. The price is discounted because the factor, the one who buys them, assumes risk of delay and the loss of accounts receivable. So it's not only time value of money, that's the delay. The loss is bad accounts. They assume those risks. Now, using accounts as collateral for a loan or an advance, the merchant retains the risk. But if they actually factor it and sell it, then the factor gets the risk. Y'all see the difference? Who actually owns the accounts if the attorney only puts the account up as collateral?
The attorney still owns it.
The attorney still owns it, right?
So whoever owns it has the risk.
Whoever owns it has the risk. And that's the two different ways to handle it. You put it up as collateral, you keep the risk. Or if you sell it at a discount, then whoever buys it has the risk. That's called the factor. All right, anti-assignment provisions on 977. Now that you know how bad assignments can be, you might want to keep from having assignments in your contract, right? Or keep it from being assigned. All right, let's say you own a house and you want to rent it out to somebody and it's your best friend's child. Do you think that's a good idea to rent it out to your best friend's child?
No.
All right, good. It's not a good idea. But you rent it out anyway. Now your best friend's child decides they're on a mission to save the world. So they invite all the homeless people in your city to go live in your home. Y'all see where this is going? You don't want to allow them to have anybody living there other than who you approve of, right? So you're going to put a provision in your lease that says anybody that's going to sublease this has to be approved by the landlord. And that you don't have the right to sublease without the landlord's consent. Have you now restricted them on their right to assign part of that location? Assign being they have the right to live there too. I mean, your lease is for the right to live in the house, right? With the duty that they have to pay you monthly rent. So, do you want them to assign the right to live in a particular room that's out of the house? That would be an assignment. Not unless you actually approved of who it is, right? Now, if they wanted to have somebody take over the entire house, and the sublease says this person's going to pay the entire amount of rent, and they get to keep the entire house, and you approve it, that's a novation. So you got to watch out between your anti-assignments and actually novations. All right, the example they give you, assignment by crew of this contractor, any interest therein, or of any money due, or to become due by reason of the terms hereof, without written consent of Caristo, shall be void. That's an anti-assignment provision. And the power to contract is trumped by the power to transfer. So if you transfer to somebody the rights, and then you come in and you revoke the contract as a whole, which one do you think controls? Anybody. An assignment versus a revocation. Yeah, the revocation controls, because if there's no more contract, you can't assign it. That's what they're trying to point out to you. Now, 9-406. A term in an agreement between an account debtor, Caristo, and an assignor is ineffective to the extent that it prohibits, restricts, or requires consent of the debtor to the assignment or transfer of the account. Now, I'm going to tell you that that's applicable to accounts. This is not a general term, this is to accounts. What it tells you is for your accounts receivable, you can't say that you cannot assign it. The general requirement for accounts is that they be assignable. Like your mortgage. Your mortgage doesn't have an anti-assignment provision in it because whoever gives you the mortgage probably wants to sell it to somebody else so that they have the right to receive the payments and they get their discounted money up front. Who assumes the risk of the payments at that point?
The person who buys it out.
The person who buys it out. But here's the problem. Isn't it secured by the house itself? So if you don't pay it, you lose the house. So there's not a whole lot of risk in buying out mortgages unless the property is just not worth what they thought it was.
Or people trash it.
Well, or people trash it, but the property not being what they thought it was, worth what they thought it was, that's what caused the real estate crash. They had people giving out loans for more than what the property was worth, and when they couldn't collect the loans and the property didn't secure what the amount was due, there's your problem.
So whenever banks are pooling the loans together, I thought they just randomly chose a section of loans worth a certain amount of money and pooled them together and assigned them or sold them to other banks.
I guarantee you they don't do it randomly. They're probably looking at your credit scores. And if your credit score is not above 650, they may want to sell your account because they may think that they have risk. But if your credit score is above 700, they may want to keep it because you're a pretty good shot at paying it back. So they do it for strategic reasons. they can get the money of what they soon think is going to be a bad account.
So if they're selling whole pool mortgages, then the most they're probably losing anyway, is that
Yeah, that's all they're losing is the opportunity for the time value of money. So they're not losing the interest because it's not theirs yet, but they're losing that opportunity by taking the cash money up front and whatever risk of loss that they're willing to get rid of. Give you an example. If a bank's got a mortgage that they're holding on you and you now have bounced a dozen checks, do you think the bank wants to hang on to that mortgage? I'd be selling it like a hotcake.
I have good credit and make my payments, and I sold mine.
Well, they probably just wanted the money to...
Each investor has different calculations.
Yeah, but if you were the bank employee who's looking at determining the risk of non-payment on a loan, and you see somebody that's just bounced a dozen checks, might you think that they're a risk at not paying the mortgage? So would you want to sell it as fast as you can to get the money and lose the risk? So banks don't do things on random. All right, Bell Ray Company, who has either not done one or have gotten called on and weren't ready. All right, if I call on you to do one today and you don't do a good job on it, then your score goes down from 100% down to something else.
So if we've done one, we have a
Sorry.
Yeah, if you've done one.
Oh, okay. Well, last semester was two, so I was making sure what.
No, I'm trying to make sure everybody gets a chance to improve their grades.
I'll take it. I went through enough to get here this morning. I'll take it.
All right, last name.
Washington.
Ms. Washington, let me mark you here too. Okay, go ahead.
Bell Ray was a company out of Jersey who had been in business making lubricants with Chemrite, and then Chemrite was bought out by what's it called, Lubricine or something? Yeah, Lubricine. So they were to assume all of the assignments and trade requirements of the same as Chemrite. But Bell Ray felt that they were not operating under those agreements, and so they sued them and filed a motion for requiring arbitration on those agreements. Or does that sound about right?
So far.
I'm sick.
Go
My
ahead.
brain is gonna fall. Please forgive me. Let's see what else I forgot. Okay, so initially the district court agreed with Bell Ray on the arbitration, and Lubricine appealed. Lubricine's appeal was that the trade agreements did not require their assignments for the arbitration. Does that sound about right?
So far.
I read it, but I was, like I said, I've been on Benadryl all week. Please forgive me.
Benadryl's legal.
It is good. In the end, the appellate court agreed with Bell Ray that the trade agreement assignment clauses did not contain the required language to limit Chemrite's power to assign the trade agreements to Lubricine, so Lubricine did have to agree with that, whatever the arbitration was.
Okay, so the court really went in and made a distinction between your right to assign and your power to assign. That's the fine line that they drew in this case. Down at the bottom of 979, it says a party's power to assign is only limited where the parties clearly manifest an manifest a different intention. It says according to the court, to reveal the intent necessary to preclude a power to assign or cause an assignment violative of contractual provisions is wholly void, such clause must contain express provisions that the assignment shall be void or invalid if not made in a certain specified way. Otherwise, the assignment is effective and the obligor has the right to damages. So the general rule, and this is in adopting 322, that paragraph, general rule that contractual provisions limiting or prohibiting assignments operate only to limit a party's right to assign on the contract, but not their power to do so, unless the parties manifest an intent contrary with specificity. So to meet this standard, provision must generally state that the non-conforming assignments, number one, shall be void or invalid, or two, that the assignee shall acquire no rights, or the non-assigning party shall not recognize any such agreement. So if you want to keep them from being able to assign, not only have you got to take away their right to assign, but you also have to take away their power to assign. You got to put that extra language in there that says it shall be void if you try to do this, or otherwise they still have the power. They may not have the right, but they still have the power, and you're going to be stuck with the assignment. It says in the absence of such language, the provision limiting or prohibiting assignment will be interpreted merely as a covenant not to assign, or to follow specific procedures, typically obtaining the non-assigning party's prior written consent before assigning. So that's what it tells you, is you got to have special language in there to take away the power, not just language to take away the right. And it gives you the language. It says shall be void or invalid, and that the assignee shall acquire no rights, or the non-assigning party shall not recognize any such assignment. You put all that magic words in there, you've taken away their power as well. In the absence of those special words, they still have the power, and you can't keep them from doing it. All right, meddling on a mortgage at the top of 981. Roy Haggett was much disturbed by a letter he received from a person, K.E. Norton, with whom he had had some arguments. Talk about an understatement. The letter said that Norton had bought from a savings bank a note that Haggett had given to the bank and the accompanying mortgage on Haggett's home. So now he owes his
Arch enemy.
Yeah, his arch enemy, for lack of better words. He has to pay his arch enemy his mortgage, right? Because his arch enemy went out, sought out his mortgage, and bought it. Now, would that piss y'all off if your arch enemy bought your mortgage?
Yeah.
Now, if you read the rest of the story, he didn't actually buy the mortgage, he paid it off. It was petty, and now he's suing to reinstate the mortgage, and the court said, you shouldn't have meddled in his business anyway. And so they denied him the relief. That's the funniest part. It emerged that he had made a mistake in dealing with the bank. Instead of buying the note, he had paid it. The court thought otherwise, concluding that Norton had acted as a meddler in Haggett's affairs and was simply out his money.
So he got a free mortgage.
I think that falls under the title of caveat emptor. Buyer beware. That's probably one of the more entertaining cases in this book. All right, section 4, contests between assignees and obligors. And this is where we get into heavy UCC Article 9, which is negotiable instruments. If an assignment of an account has been made effective by Article 9 of the UCC, the account debtor and the account debtor has received appropriate notification of the assignment, a payment made on the account to the original creditor will not be credited to the account debtor. Now, plain English. You take out a mortgage with mortgage company A. Mortgage company B buys your mortgage and sends you a letter that says send future payments to us. And then you send your mortgage payment to your original mortgage company A. Mortgage company B does not have to give you credit for that payment. Once you've gotten notice to pay it to the new owner, you don't get credit for payments to the wrong place. That's what it says.
Where does that money go then?
It's a gift to your mortgage company, your freshman.
Don't you usually say something like you have 30 days or something?
Yeah, you got 30 days to try to get back.
Window.
But most people don't keep track of that. All right, so the right of an assignee is not subject to defenses or claims of the obligor which accrue after the obligor receives notification of the assignment, except as stated in this section or as provided by statute. That is 336 of the restatement. Now, if the payment was made before you got notice, they're supposed to give it back to you so you can pay it to the right person. But once you've gotten notice, you're out of luck. All right, DeLacy Investments versus Thurman Remax. Who needs one?
Called me and I did one, but I can get one.
Okay, name?
Siegel.
Mr. Siegel, it's yours.
Alright, so Stephen Thurman entered into an agreement with Delegate Investments where he would sell his factoring receivables. Then he got another job where he was working for Remax as a real estate agent there. And
Can y'all hear him?
okay, alright, let's speak a little bit louder. So Thurman entered into an agreement with Remax where he would get his commission would come from whatever profits he would get that was greater than his past due financial obligation. And then he was actually fired from Remax because for various reasons, and at that time he had $11,126.38 in overhead debts. And Delegate Investments filed a suit trying to get their receivables from his initial contract. And the court later decided that because of his agreement with Remax already, that Delegate wasn't entitled to any receivables at that time because his debts, they didn't specifically request to be part of that contract, essentially. So black letter law on it was that an assignee of the plan take no other or greater rights than the original assignor and cannot be in a better position than the assignor. And the court decided from another case in that factor that he can't be in a better position than the original contracting party, and since DeLacy didn't agree to Thurman and Remax's original contract, they couldn't receive their credit that was due to them because Thurman already owed that debt to Remax in that case.
Okay, did y'all understand the facts of this case? Is there anybody who didn't?
I didn't understand.
All right,
I'm lost.
let me kind of explain to you. The realtor went to work for a real estate broker, and the broker said, I'll pay your expenses on selling homes, and I will recover those expenses out from your commissions. So part of the expenses are putting it on MLS. Some of it's advertising, some of it's going out and digging a post hole and putting a for sale sign out in the front yard. Part of it is cutting the grass to make it look presentable. All of these expenses, the broker is paying up front and is agreeing to take those back out of the commissions that the real estate agent earns from the sales of the homes. Everybody so far? Now, the real estate agent signed an agreement that says to this factoring company, I give you the right to receive the proceeds from whatever commissions that I earn. And this factoring company actually told the real estate company, we have the right to receive his commissions. Is everybody following so far? Now, the problem is the real estate company had a good lawyer draft up their contract that says you get whatever is left after you pay off what you owe to the broker for your expenses. You only get what's left. In this case, he had built up $11,000 something in expenses. His commission was only $10,000 from the sale, so he paid off $10,000 of the expenses and still owed $1,000 or more to the broker, and the factoring company came in and said, hey, wait a minute, he got a $10,000 commission. We're entitled to that money. And so they sued the broker, saying you should have given us the $10,000, and the broker said, that's not the way it works. Our contract says we're entitled to recover our expenses before he gets his money. And the black letter law is exactly what he told you is, you can't give any greater rights than what you have. He didn't have the right to get any of that commission from the $10,000 sale because he owed $11,000 in expenses. And because he didn't have the right to get the money, then the company that he sold his rights to didn't have any rights to the money either. Now, is that cleared up for everybody? Like an attorney working on a contingency contract that says, I'm going to take my attorney fee, which is a third, plus any expenses out of your recovery. Does the attorney get anything if there's no recovery? No. No. But if there is a recovery, what's the first thing that comes out of their proceeds? The expenses, right? The attorney's got the right to get those expenses first. Now, does the client have the right to have his shoulder surgery paid before the attorney recovers their expenses? No, because the client doesn't get the proceeds until after the expenses and the attorney's fees are taken out. You can't give what you don't have. Now, if y'all think that this is a crazy way or to do business, how many of y'all have friends who've sold cars? Brand new cars. You know the way that they get paid?
Draw.
They have something called a draw. So every 2 weeks they get a check. But the car company has the right to recover those advances that they pay you on your draw from the commissions that you earn from the sale of your cars. So who gets paid first when you sell a car if you've already taken a draw?
The car company.
The car company gets their expenses back first. And then anything that's left over, you get a check for the difference. And then if you've sold your right to receive that payment to somebody else, they don't have a right to get it until you have a right to get it. What that technically is, it's a breaking down of priorities. And when you start looking at assigning particularly the rights to receive payments under Article 9 of the UCC, the first in time is usually the first one that's going to get it. The exception is you can't give them any greater rights than what you have. That's what you need to get out of this case. Nemo dat qui non habat. No one may transfer more than he owns. That's on 985. And I'm not going to test you on that Latin phrase, but it always impresses friends and family when you use Latin phrases. All right, look at the bottom of 984, UCC 9-404. I've got that whole UCC highlighted because that is black letter law. Now on 986, it says a perfected security interest is generally effective against creditors except as otherwise provided in the UCC. Now you need to know, what is this term perfected security interest? Well, you have an interest in receiving somebody's money if you advance them money, right? Either as a draw or a right to the proceeds from a settlement or the right to proceeds from real estate sales, you creating a right to receive that money. Now, perfected, if you want to get proceeds from the sale of heavy equipment, because you have supplied the heavy equipment to the company for them to sell it, then you want to get a security interest in that, and you file it on a UCC-1 form. You file it actually with the Secretary of State. That lets everybody in the state know that you have a right to this piece of property, whatever the tractor or backhoe or whatever it is that you're allowing them to sell and pay you back for, and that everybody's given notice because it's on file with the Secretary of State that you have a security interest in that. Now, you have a security interest in it when you provide it to them to sell it. But when you record your statement, your UCC1 down in Montgomery, you have perfected your security interest, which means that you have filed, officially filed, and now you're in line with priority to get payment. And with a perfected security interest, you're usually one of the first in line. If you are the first, then you get the money first. Let me give you an example about how that kind of recording stuff works. Say I've got a house that's got a first mortgage. And then I go out and I get a second mortgage. And you decide you don't like this house anymore, you want to sell it. You sell it for X number of dollars. Who gets paid first?
First mortgage.
Why?
Because they were the initial interest in the house.
Because they recorded their interest first, right? Now, who gets paid second from the sale of your home?
The realtor.
The second mortgage, right? Because they filed second. Now, who gets paid third? Yeah, if there's anything left, you get it, right? But you got to pay off everybody that's got the security interest who perfected it before you get your first dime out of it. So there's why you want to hurry up and file stuff. And Alabama is one of those first to file states as to giving you order when money's being dispersed. 987, your UCC1 form, called a financing statement. All of paragraph 2 basically describes what I just told you about, the right to receive the money first. All right, timing under note 3, the Thurman CE security agreement was made in 2001, but Thurman Remax agreement was made in 2003. Because the account in question was generated by the latter, CE could not have had a security interest in it before 2003. Do y'all understand what that just said?
They can't have interest in something.
I file something that says I have the right to receive whatever proceeds that you get. Say I filed that back in 2001 and I give notice to the company that I have this document filed that gives me interest in whatever money you receive. And then you actually sell something and create the right to receive the money from your employer. Well, the first person that did the rights back in 2001, was there any property to receive in 2001?
No.
Not yet. Nothing identifiable. But when you actually sold something in 2003, now something, it's a right that's been created as soon as you make the sale. So their right didn't actually accrue until 2003 when the actual right to receive the property was created. Even though they filed in 01, they didn't have the right till 03 until the right was created itself. Everybody got that? All right, modifications. 9-405 deals with modification of an assigned contract. A modification of or a substitution for an assigned contract is effective against the assignee if made in good faith.
Can you give an example?
Yep. Let's say that I've got a contract to sell a home, to receive rent payments on a home, okay? So I'm getting what, $500 a month, and I assign the right to receive the proceeds to my bank. Even though I've made the contract, I assign only the rights to receive the proceeds to my bank. So the bank's getting used to this $500 a month to come in, and now all of a sudden I go and modify my agreement with I'm the landlord, I modify it with the tenant, that I'm going to reduce that from $500 down to $450. But I have signed the right to receive the money to my bank. Is it going to be effective against the bank? to receive now only $450 instead of $500? Yeah, they loaned me money,
Okay, so.
and now they're receiving the $500 a month, and I modified the rental contract on the lease so that it's now not $500 a month, but only $450.
And then the extra 50 on the.
Well, and that's what it says, is that a modification or substitution for an assigned contract is effective against the assignee if made in good faith. The bank
Okay, thank you.
to receive the money.
My lines keep getting crossed with these words.
Okay, the assigned contract is the lease to get the rental payments. So I want to modify that contract from $500 down to $450. Is it effective against the bank?
The rental payments are to pay back the mortgage, is that what you're saying?
To pay back a loan of some type.
Okay, so yeah, it is. I mean, you changed your terms if you agreed, told the bank that you were gonna pay them $500 a month, and now you've renegotiated.
Right, my assignment says I assign to you the right to receive the payments under my lease.
Oh, it just says payment. It doesn't specify an
It
amount.
doesn't say $500, it says right to receive the payments.
Okay, then 450 and
But
then.
you can't change.
So
it
if I
back.
change the lease from $500 a month to $450 a month, and the bank only has the right to receive the payments under the lease, is it effective that the bank only gets $450 instead of $500?
Yes.
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 If I do it in good faith. Now, let's enter some other facts that we may consider. What if I had an argument with my bank that says, I'm tired of you, you didn't honor one of my checks, and therefore I'm going to take it out on you. So I reduced the rent down to $450 instead of $500.
Bad faith.
That doesn't sound like good faith, does it? Now, what if I know that my tenant has just taken a new job, which is a pay cut, and they can really only afford $400 a month, but I drop it down to $450. And so we modify our lease to say $450 instead of $500 is what the monthly payments are going to be. Is that effective against the bank?
Yes, because it was made in good faith too.
Because it was made in good faith. So the key here is, what was the reason for the modification? If it had, it's got to pass the smell test, for lack of a better term. If it was good faith, reasonable, in fact, what they say, honesty in fact and the observance of reasonable commercial standards and fair dealing on the top of 988. If that was reasonable commercial to reduce the rent by 50 when they really couldn't afford 400, but you're still getting 450, is that a reasonable commercial practice?
Yeah.
Probably.
So the assignor has to act with good faith for it to be effective against the assignee.
Yes.
Okay.
The landlord has to act in good faith for it to be effective against the bank. But you got to use the magic terms of assignor and assignee. And if it helps when you're writing out your facts, if you're doing an essay question, put down the bank as the assignee, and that way you know bank is assignee, and the assignor is the landlord. Put landlord, paren, assignor, and then that way you can keep it in perspective as to which one's the proper one. Examples really help a whole lot more on this because of the confusing language. All right, note number, well, the note on 988, rescission. It doesn't work on rescission. The bank doesn't have to accept the terms if you rescind the note, only on modification. And then the legislatures have done something about that. All right, 989. Agreement not to assert defenses against the assignee. Probably one of the more entertaining is what they explain in this first paragraph, I think. This introductory section. An example of misfortune occasioned by a waiver of defense clause is that a law firm desiring the use of computer equipment during negotiations of a lease, the prospective lessor, the law firm, the computer company, induced the agent of the firm to sign a lease agreement saying that it was common industry practice to execute an undated document in advance and promised to hold the document in escrow until the deal was reached. Now, how many of you does that throw up red flags?
Never signed it under the document.
Never sign one that's not completely filled out, much less a blank one. So no deal was reached and the would-be lessee never received the equipment. Nevertheless, he had to pay according to the lease because of the assignment and because the waiver of defense clause in the document. A law firm didn't bother to read the contract and see that we can't assert any defenses such as we never received the equipment, so they had to make the payments anyway. So that's what the agreement not to assert defenses against the assignee, that's what they do. 9-404 clauses having the object are commonly known as waiver of defenses clauses. And it says a waiver of defense clause can override the defense based on fraud of the worst type. They lied to me and said they were going to bring me a computer. But I signed this contract and said I'd make payments. The fact that they didn't deliver the computer and that you're not using it is no defense. You waive that defense. Now, CFR, 16 CFR 433.2 requires certain contracts include prominent anti-waiver defenses clauses. And it's under note number 1. They put it in big letters. If they don't make it stand out, it's not going to be effective. Any holder of this contract is subject to all claims of defenses which the debtor could assert against the seller of the goods. Failure to include this text in 10-point bold-faced type in a consumer credit contract may be a federal offense in connection with the sale or lease of goods or services to a consumer. It's a crime, folks. That's what it means. It's an offense. For you to fail to put that in 10-point bold print in your contracts. All right, financiers versus consumers. Who do you think has the more expensive lawyers?
Financiers.
Yeah, financiers, banks. So do you think they're standard form contracts or maybe forms of adhesion? That's what that section says. Linkage, assignor, and assignee. In each case, the claimant sought to override the buyer's defense by presenting itself as a holder in due course of a negotiable instrument. What that means, as a holder in due course, you buy a piece of paper that's usually assignable, and if you didn't know any particulars about the deal, but you just bought the note, then you are considered to be in due course, a holder in due course.
Where is this?
This is on the top of 992, bottom of that first paragraph. What they tried to distinguish in here is that the bank worked closely with this person all the time, so that they weren't really in due course. They were a partner in this, and therefore they should not have the defenses because they were a partner. But if you are a holder in due course, you have defenses. So if you're not involved in the transaction, but you're just somebody that's buying a note on the street, you have defenses. All right, introduction to Chemical Bank versus Rendon Professional Association. That intro was useless. Let's go to the Chemical Bank. I read these things, but I don't know why they just didn't go straight into the decision. Unless they're going to give you pointers like this is black letter law, you should get out of this case. That's what an intro ought to do. All right, who needs one? I see your hand. Yeah, Stretching.
I
Okay.
do another one.
Yawns and stretches are fair game. All right, Ms. Dudley, how about you?
Okay. Chemical Bank versus Rendell Professional Association. In this particular case, Intertel installed an office system in a law firm, for Rendell Professional Association, which was defended due to a lease purchase contract under which Rendell would make monthly payments up to a certain date. Rendell received a notice that Chemical Bank planned to purchase the payment rights from Intertel. This document required Rendell's consent to make payments to Chemical and provided that Rendell agreed that this obligation would be absolutely unconditional and payable whether or not the lease was terminated. Without any defenses or claims it had or may have against Intertel. Rendell's office manager consented to the notice document that Chemical Bank paid Intertel $8,800 for the assignment of Intertel's right to receive payments from Rendell. After 3 years of making payments to Chemical, the phone system started having malfunctions. Rendell replaced the phone system and refused to make further payments. And action was then commenced and the evidence was reviewed by a special master who issued a report in favor of Chemical. Intertel, in the meantime, went into bankruptcy. Representatives of Chemical testified at trial that Chemical and Intertel were not interrelated and that Chemical's investigation of the Intertel account revealed no claims or defenses regarding those purchase agreements. So that's kind of the basis. The issue is where the assignment was made for value in good faith and without notice of claims or defenses is a waiver of claims and defenses against an assignee enforceable against a non-consumer buyer under the UCC. Basically, that's the issue.
That's it. In fact, here's the clause that they signed, the indented paragraph on 993. As lessee, you agree as follows, that your obligation to pay directly to the assignee, the bank, the amounts which come due as rentals as set forth in said lease, shall be absolutely unconditional and shall be payable whether or not the lease is terminated in any way, and you promise to pay the same notwithstanding any defense, set-off, counterclaim whatsoever by breach or otherwise which you may or might now or hereafter have against the lessor.
Did they just not read it?
And it was a law firm. Now, would you sign a document that says that? I wouldn't either. But that's what they did. Now, so you mentioned special master. Let me tell you about what a special master is so that you understand the procedural structure of this case. When a lawsuit gets filed, it usually goes before a judge. However, when there is specialized information to hear, the judge can appoint somebody who's called a special master who will hear the evidence. They have the power to issue subpoenas, the power to swear in witnesses. What the special master has to do is create a report based on all the evidence that they've heard and make a recommendation to the judge. For those of you who are really interested, it's Rule 53 of the Federal Rules of Civil Procedure. It's also Rule 53 in the Alabama Rules. You'll study that next year. Nonetheless, it's somebody appointed by the judge to hear all the evidence and to make a decision. And in this case, they did a report and they made the recommendations a certain way, and now they're objecting to the recommendations and say they messed up. Doesn't matter, the judge went along with the recommendations from what I can tell. All right, the bottom of 993, the requirement of valid waiver are that there was an agreement by a buyer who is not a consumer to waive defenses against the assignee and that the assignment was made for value in good faith and without notice of a claim or defense. That's what's required for a valid waiver. That's your black letter out of this. And then they take the opportunity to twist that knife in the law firm's back by saying the defendant is a professional association, a law firm, not in need of special protections often afforded to unwary customers. Do you, yeah, you should know the law. So do you see lawyers getting treated differently?
Yes, held to a higher standard.
They are held to a higher standard. And then at the bottom, Article 2-209 states that an agreement modifying a contract within this article needs no consideration to be binding. All right, assignees' liabilities. The FTC has created something called the holder rule. This is at 996. Again, it's in big, bold print. Any holder of this contract is subject to all claims for which the debtor could assert against the seller of goods or services obtained pursuant hereto. All right, let's talk about your credit cards. How many of you have got a credit card? Not a debit, but an actual credit card. When you buy something with a credit card, who actually pays the merchant for it? Your credit card company, which is usually your bank, right? Now, who do you owe the money to? The bank. But if your bank sells your credit card account to somebody else, and they give you notice of who to make the payments to, who do you owe the money to? Whoever bought the account, right? Now, you'll see a lot of that in the district court, whatever county you're from. They will come in, it's a collection company that comes in, and they're trying to collect credit card accounts. Does everybody follow? These are the companies that want to actually introduce the billing statements that says, here's how much you paid, and here's how much you owe. And they want to get the judge to enter a judgment for the amount that you owe, plus all the interest and their attorney fees if that's part of your agreement. So this phrase, the holder rule, says that the holder of this contract or the holder of your credit card contract that's entitled to receive the money is subject to all the claims which the debtor could assert against the seller of the goods or services obtained pursuant hereto. So what if you bought something and it didn't work and you took it back? Would that be a defense to the money that you owe to the credit card company?
They put it back on the card.
Possible.
But they sold your account before they put it back because you just happened to hit them at the right time.
It says pursuant hereto. Doesn't that mean continue? Or does that mean stop now?
So they sell your credit card account the day after you make a big purchase. And you take the thing back a week later because it just didn't work. Now they're suing you to collect all the money for that purchase. Don't you have a defense that you actually returned it?
Yes.
That's what the holder rule is. They can't collect it against you if you have a defense such as you took it back.
If you took it back and got the money for it, then you still make
No.
a charge.
So they put it back on your account,
Okay.
but your bank has already sold the amount to receive that to somebody else. So now they put the money back on your credit card account, your bank's got it, and not the person that they sold the account to because they didn't get notice of it. Does everybody get that example? All right, UCC 9-404. Any claim has been changed to any claim in recoupment. A claim for an account debtor against an assignor may be asserted against the assignee under subdivision A only to reduce the amount that the debtor owes. That's the recoupment. So can you get more than what you owe? No. All right, the holder rule spelled out on 997. Any holder of this consumer credit contract is subject to all claims and defenses which the debtor could assert against the seller of the goods or the services obtained pursuant hereto, or with the proceeds thereof. Recovery hereunder by the debtor shall not exceed the amount paid by the debtor hereunder. So you can get the money back, but nothing more. Notice also the Truth in Lending Act holder rule is also spelled out for you. It's almost identical. All right, assignees in contest with third parties on 998. Successive assignees of the same right from the same assignor.
In English?
You sold the account to two different people.
Oh. That doesn't seem like a good idea.
That's the same right to two different people.
Is that even legal?
No.
Okay.
Short answer, no, it's not legal. Because if you don't own the right and you're selling it, that's fraud.
It's almost like kiting checks.
Yep. So it says successive assignees to the same right from the same assignor. Look at restatement 342. And here it is. The primary restatement rule about priority is the first in time rule. So the first one you sell it to has the right.
Now, can the second one come after you for breach of contract?
Yes.
Fraud.
Now look on 999. U.S. Claims versus Floman Half. Who wants to do that case?
You can do it. You do that one. We'll be done.
All right, Stillwater Asset-Backed Fund, U.S. Claims. They had a conflicting interest in the assets of a New York attorney. One of them filed a UCC. I think that's right. The primary code rule about priority in these cases is the first to file or perfect. So either the first sale, when you have conflicting security interests, and then there's another test about who's the first to file. If you sell an account to two different people, let's say you got two employees working for you on your collection, on your accounts receivable. Both of them happen to hit the same account. Both of them sell it, but both of them sell it to two different people without knowing that the other has sold it. So you're not intentionally doing anything illegal. One of them sells it to Bank A, the other one sells it to Bank B. Bank A sale technically happens first, maybe the morning of, and the sale to Bank B happens second in the afternoon, but Bank B is on its game and it files its security interest with the Secretary of State first.
It's whoever files first, isn't it?
That's what it says. It's the first to perfect. And the first to perfect is the one who actually gets the money first. So there's a first in time rule if there's no perfecting, and then if there is perfecting, it's the first to file. And it says the following security interests are perfected when they attach the assignment of accounts or payment intangibles, which does not in itself or conjunction with other assignments to the same assignee transfer a significant part of the assignor's outstanding accounts or payment intangibles. The reason that that's in there the way it is, it says a significant part of the outstanding accounts, is because the UCC has something in there about bulk sales. It's intended to avoid the circumstances where you do bulk sales. Look at Restatement 342. And then it says in here, toward the bottom of that fact pattern before Davis, says that being accounts, they were not even general intangibles. They're specific. They're accounts receivable. And it says the purpose of the clause is to save from ex post facto invalidation casual or isolated assignments, which no one would think of filing. Any person who regularly takes assignments of any debtor's account or payments should file. So Bank A should have filed. Bank B did. And if that's the way you perfect your interest, you need to make sure you file. The fact that a bank is sloppy and doesn't, that's their fault. Now, what difference does that make? Okay? if you don't file or if you do file? Well, filing gets you the right to receive the money first. And if you don't file, then you don't have a secured interest, and you are considered to be an unsecured creditor. What does an unsecured creditor mean to anybody?
Probably not gonna get your money.
Yeah, you're not getting it back.
All right, when you are a secured creditor and you have the right to proceeds from this particular piece of property, means when that property is sold or collected, you have the right to receive proceeds from it. That's what a secured creditor is. An unsecured creditor means you don't have collateral. And so, in the pecking order of things, you're the last to be paid. And if you look in here, it talks about bankruptcy. Yes, ma'am.
When you said you're the last to be paid, does that mean that bank A, then the person can sell it, and then that bank?
No, if Bank A bought it first in the morning and Bank B bought it in the afternoon and Bank B secured it, then Bank B gets paid first.
Because they're secured.
Because they're secured and they get the money from the proceeds of that.
Bank A is not secured.
So if there's any money left over, then Bank A may get their money out of that.
But does Bank A get their money after the, seller? No, Bank A will get it next.
Bank A gets it next.
So that's the same as if you have a second mortgage.
Yes,
So the second person is not secured either.
except when you get a second mortgage, you are secured because you still have collateral, but you're just second in line. An unsecured comes after the second in line. And if you have a third mortgage, they come after them. If you have a fourth mortgage, they come after them. When you're unsecured, everybody that's secured gets paid off first. And then if there's anything left, then you get your money.
And it's not secured on the same dollar amount. They're secured under, or usually it's secured under separate dollar amounts. One may be 200,000, the other one may be 40,000.
Yeah, if they specify how much security interest they have in it, then they get up to that amount. And they get paid before the next person in line gets paid. Now, at the bottom of 1,000 and the top of 1,001, they talk about bankruptcies. Ordinarily, if a person is not bankrupt, then they pay the priorities off in order according to your first in time to file. So the first to file gets paid, then the second to file, then the third to file, and then the fourth. And then that's all your secured creditors. And then the unsecured creditors get next in line. Now, bankruptcy court changes that. Bankruptcy court, whenever you file a bankruptcy, you'll have a trustee who is technically in charge of your assets. Because the court says you need a trustee because you can't manage your assets because you have so much debt. You need the court's help. The bankruptcy code actually sets out some rules about what trustees can do and cannot do. One of those is that they can avoid security interests. They can actually go in and have the court avoid those transactions. They can modify executory contracts. One example that was actually in my employment law book was the Alabama Symphony Orchestra, decided by Judge Tamara Mitchell right down over on 5th Avenue North. The orchestra went in and said, we can't afford this, we're having financial difficulties, and they filed bankruptcy. And they went to the musicians and said, you know, we have a contract with you to perform, and we'll pay you for that, but we need to modify the terms of our agreement. And the musicians said, no, we're not going to take anything less. And because they refused to negotiate, the bankruptcy court said, okay, then your contract's no good. And they voided the contracts. And it came in the context of employment because they were actually hired to work at the symphony. So bankruptcy's got some strange things that they can do with it. They're all spelled out in the code, but it's a different set of rules than if you are not in bankruptcy. They can avoid security interests. If you have a lawsuit for a personal injury case and you don't claim it as an asset in your estate, then guess who gets the proceeds from your accident?
Bankruptcy.
Your creditors. Because if you don't claim it as an asset, you can't claim an exemption to it either. So, what you get out of 1,000 and 1,001 is that bankruptcy changes that drastically, other than the first to acquire if it's not secured, and if it is secured, it's the first to file.
What's a lien in all of this?
What's what?
What would a lien be in all of this?
Well, those are liens.
Okay, so
When you have a security interest, it's a lien.
Where does a student loan fall in bankruptcy?
Where does what?
Student loans.
Most of them are non-dischargeable.
Oh, so even if you file bankruptcy, you still have that.
You still have to pay back your government-backed loans. Now, if you get a loan that's not government-backed, I think you can discharge them.
Oh, I should have done that. Can I get one and pay them off and then? We need to talk.
All right, and child support. You know you can't discharge child support or alimony either, right? That's just in the bankruptcy code that those are non-dischargeable. Other things that aren't dischargeable, whatever damages you cause while you're driving under the influence of alcohol, and damages arising from intentional torts, non-dischargeable. So bankruptcy is not the answer to all, but when you get a client that comes in with a breach of contract case and says they're suing me for $1 million,
Well, better file bankruptcy.
file bankruptcy and you can get out of it. In fact, the lawyer I used to share office space with, every morning he would get on Alicourt and look up all the new cases that have been filed, and he would send a letter to everyone that was a defendant and say, I just noticed that you've been sued. We can take care of your problems by filing bankruptcy. Now the State Bar has changed the rule that you can't send them the letter until they've been served with the summons and complaint.
So you found out from him?
Yeah.
Surprise, you've been sued, and oh, by the way, you should file bankruptcy.
Hey, what? Yeah. And send them letters. Now, that is unsolicited contact with somebody you don't have a relationship with. There are rules for that. It's under the advertising rules for the State Bar. And they've changed the rule that says you can't contact them before they've been served with their court papers. So you have to, they've kind of frustrated that. But there's more than one attorney that used to do that.
That's kind of like ambulance chasing, ain't it? Like,
Yeah.
The financial ambulance struggle bus.
All right, folks, that's it for Contracts 2. If you came in after I called roll, please come see me and get on the roll. Next week is going to be the review.